Welcome everyone on this call. Thank you for joining us. This is the 7th installment of our Labor and Employment webinar series. Con Maciel and Carrie is pleased to have you, and for one of the first times in the last few months, we are doing a webinar that is not related to COVID-19, although some of the issues with drug testing and relating to the ADA actually do involve some of the same situations and scenarios that and potentially implicate COVID-19. But for now, we're giving you all a break from specific COVID-19 related materials to just talk about marijuana and drug testing and what to do in those scenarios given the ever-changing legal landscape in various states. Joining me on this webinar is my associate, Dan Deacon, and for those of you who don't know me, my name is Jordan Schwartz. I've been a partner at Con Maciel Carey since we started back in, I believe it's 2014, coming up on our 6-year anniversary. And aside from advising and counseling on all matters related to COVID-19, I specialize in ADA issues, which is going to be a significant portion of this presentation today, and all the other typical employment and labor-related issues, such as the Fair Labor Standards Act, wage and hour issues, FMLA, discrimination, harassment, and counsel my clients on all ways to positively interact with their employees. And now I'm going to introduce Dan Deacon, and he is going to cover the first half of the presentation.
Thanks, Jordan. I will do a quick introduction of myself. My name is Dan Deacon, and I am an associate at Con Maciel Carey. I've been at the firm for about 5 years now, coming up on 5 years in October. I work in both the workplace safety practice group and the labor and employment group. So with that, I represent employers during inspections and investigations conducted by federal and state OSHA, responding to notices of employee safety complaints, and I handle the full range of litigation related to OSHA citations. And on the labor and employment side, I represent and advise employers in all aspects of the employer-employee relationship, including wage and hour disputes, Title VII issues, EEO, and I assist employers in revising and drafting employee handbooks, workplace policies and procedures, safety manuals, and the like. So as Jordan mentioned, I am going to go over the agenda quick and cover the first half of the presentation today. And we're going to begin by discussing federal and state laws on work-related drug testing. We're going to follow that up with drug testing restrictions and OSHA's injury reporting anti-retaliation rule. And then Jordan will be covering issues related to the ADA, the Americans with Disabilities Act, and the impact of state marijuana laws on employers. So first, we want to set the stage here and go over what laws may or may not be out there related to drug testing and marijuana. So the overarching question that we're dealing with throughout this presentation and questions that you as employers should be asking yourselves, of course, are, can we legally require current employees to take drug tests, right? To what extent can we drug test employees? When can we do it? How can it be done? And really the answer to that question is it depends, right? The laws on drug testing are, for the most part, state specific, and there are some nuances there related to federal law, federal regulation, OSHA's anti-retaliation rule. But the overarching question that you need to answer is, can we legally require current employees to take drug tests? Can we legally require job applicants to take drug tests, right? So the difference between employees and job applicants, the pre-employment drug testing process, to what extent can you conduct pre-employment drug tests? How do you do it? and when can you do it, right? And that final question is really to sum everything up. How can you ensure that you don't run afoul of the law? So we're going to go over some key areas of the laws and where you should be looking to make sure that you are compliant with federal and state laws and that you have a compliant drug testing program. So the overarching legal concerns are what you see on the screen here, and there's really 4 of them. You have invasion of privacy, and that's related to state law privacy issues. You want to be aware of whatever privacy issues that your respective state law has. For example, there may be limitations on how drug testing can be implemented and to what extent you can perhaps conduct an in-person observation of a drug test sample, et cetera. So those are some key privacy issues that you need to look into prior to rolling out any drug testing program. Discrimination claims. This is a very important one. You want to make sure that you are not singling out a specific protected category. And when you are implementing these drug testing policies in your programs, you want to look at your entire workforce. If there is a certain job, not task, but a job position for which a certain protected category makes up a large portion of that, singling out that job category may not be the best idea, singling them out for drug testing. So evaluating those potential discrimination claims and making sure that you're implementing the policy in a non-discriminatory manner. In other words, it applies to all employees regardless of race, color, sex, education, gender, etc. So violation of state laws and procedures is another one. While you may have a legal right to drug test employees, you need to follow specific state laws and or procedures. For example, in Maryland, close to where we are in DC, an employee can bring a legal challenge against an employer who doesn't have a legitimate business reason to test that employee or doesn't provide appropriate documentation following a positive test result. And that's just one example of the many state law nuances that are out there that you need to be aware of. And especially for those national employers, this does become somewhat of a headache and it's dizzying to follow, but it is very, very important that you make sure you get it right. And then finally, the last part, the last legal concern that you should be keeping in the back of your mind is defamation. Publicizing test results, for example, would be an issue and could be subject to a defamation claim, especially if there is a false positive result and that gets publicized to other coworkers or other future employers, what have you. The idea here is you want to keep any drug testing positive or any drug testing results positive or confidential, I should say. So now moving on to drug testing and employment law issues. And right now we're going to get into the background of the genesis of drug testing laws. And we have to start first with federal law. And this should come as no surprise to many of you, but there is no comprehensive federal law that regulates drug testing in the private sector workplace. So the U.S. Supreme Court has ruled that while drug testing does infringe on an employee's privacy, it can be necessary in order to protect the health and safety of others. From a federal law perspective, drug testing is permissible, okay? And with that, it left the door open to for states to regulate that and implement their own laws. And that's why we have a patchwork of different drug testing laws, regulations, prohibitions throughout this country. And that is really the background of what we're working with. So what does Uncle Sam say, the federal government? Well, there are a couple laws out there, again, not many, actually none, that apply to private sector employers. There is the Drug-Free Workplace Act, and that applies to mostly federal contractors. So any organization with a federal contract, I think, is worth more than $100,000, and any organization receiving federal grants of any size are subject to this Drug-Free Workplace Act. But all it really requires you to do is implement a drug-free policy and program, and to provide that to employees. What it doesn't do, it does not require those organizations or employers that are subject to the law to require drug testing. Okay, so it's limitations or requirements related to drug testing are non-existent. There are none. What else does the federal government say? Well, as it relates to marijuana, it says that marijuana is a Scheduled I drug under the Federal Controlled Substances Act, and that's a really important piece that we're going to be talking about a little later in the presentation. But the federal government has identified a number of drugs that are considered controlled substances and are de facto illegal in this country, marijuana including being one of them. And then there are certain testing requirements for those subject to certain agency regulations and requirements. So those that are subject to DOT or DOD, Department of Transportation and Department of Defense regulations, they may have certain drug testing requirements that you need to comply with. For example, in the DOT process, there is mandatory post-incident drug testing, and there's certain requirements and steps that you must follow in implementing those drug tests. So we're going to go over them right here. What are those DOT drug and alcohol testing? This is one important area of the law that a lot of employers are subject to, especially if you have drivers working for your company. Those drivers are typically subject to the Department of Transportation regulation. Marijuana specifically is prohibited, and you can be tested for marijuana if you are a DOT covered employee, regardless of whether marijuana is legal in your state. What type of tests are available under the DOT regulations? Well, there's a host of them that you see on the screen here. There's pre-employment testing, post-accident, as I mentioned, mandatory post-accident drug testing, reasonable suspicion testing, random, and there's specific regulations that outline how random drug testing is to be followed. And then there's a specific process for return to duty tests and follow-up testing, and those are for individuals that may have tested positive in one of the other 4 categories of, or 3, I should say, the post-accident reasonable suspicion or random testing, or for those individuals that go on a leave of absence related to substance abuse. You'll be subject to the return to duty or follow-up drug testing policies under the DOT regulations. And a lot of these programs, especially as it relates to DOT drug and alcohol testing, those are traditionally not handled internally by an employer. There's specific companies that deal directly with these DOT drivers, and a lot of this drug and alcohol testing requirements for DOT covered employees is outsourced, just because there are so many regulations and requirements that you need to be aware of and to make sure that you're following. Adding those requirements on top of the myriad of other state law requirements that your general workforce is likely subject to can be a headache for a lot of employers. So employers need to obtain drug and alcohol testing information from an applicant's previous employers over the past 2 years. That's part of the employment onboarding process. All of the drug testing information is obtained and maintained in the DOT clearinghouse. So there's specific reporting obligations that you have to comply with as well if an employee does test positive. And again, this is a comprehensive set of regulations that employers need to be aware of. So that is something that is somewhat challenging, and it's best to take a hard look at whether it's worth outsourcing that if you do have employees subject to DOT requirements. Some other implications that you need to consider are labor relations. implications. Of equal importance here is the somewhat controversial nature of drug testing in labor management relations and the potential for legal challenges in that arena. So you need to review your CBA, the collective bargaining agreement, to determine if testing is covered to the extent you are a unionized workplace. Otherwise, there's a duty to bargain, and failure to do so could result in an unfair labor practice charge. So if you're a union, if you have a union workforce, make sure that you take a look at that CBA and that you're checking the boxes. Don't go drug testing people without looking at that and making sure that it is a covered provision in the CBA. So moving on to state law, and this is where we really get into the specifics of where drug testing is largely regulated. So generally, employers have a right to test for drugs unless there's a restriction of state law, right? As the body of law on employee privacy and related issues continues to evolve, testing programs not explicitly authorized by law could be open to legal challenges. So again, going back to those privacy issues, that's a developing area of the law. It's very state specific, something to consider and research prior to implementing any drug testing program. So many states have enacted provisions imposing drug testing restrictions of various kinds. There's limitations on drug testing related to reasonable suspicion or probable cause situation. Some states impose restrictions on public sector employees, but not private sector employees or private companies. There's other states that mandate specific methods for handling of specimens and use of test results. And there's many limitations on pre-employment marijuana testing. So obviously there's this, like I said before, patchwork of state laws that you need to consider. And this is just 4 of the many nuances that you might see. You know, there's some states that only authorize testing for employees in safety-sensitive positions. Other states explicitly authorize random drug testing, while some outright prohibit it. And there's many states that have no restrictions whatsoever. So the fact that your state has no drug testing restrictions, perhaps, that doesn't necessarily give you carte blanche in terms of the decision of whether to test and how, though. And we're going to talk about that in a few slides here when we get to the OSHA piece of the presentation. So here's an example of the different types of restrictions on the types of drug tests and drugs tested for that state laws have rolled out. And we'll get to the bottom here is just a list of some examples. But employers operating in multiple states, right, nationwide employers will almost surely have different requirements in each state that they operate regarding what drugs they can test for, how, when, and there may be limitations on some, none, or all of the types of drug tests that may or may not be at an employer's disposal, right? So we have pre-employment reasonable suspicion, post-incident drug testing, random testing, and then that return to duty follow-up testing. So the overarching question that you have when researching these state law issues is, to what extent is this permissible, prohibited, restricted, and in some manner, you want to nail down each one of those types of drug tests to make that evaluation. So with respect to what drugs an employer may test for, state laws fall into typically one of 4 categories. So first, there may be no restrictions on the types of drugs that employers can test for or the testing method in some of the states that you have on the screen here: Illinois, South Carolina, Alabama, Virginia, New York. Illinois did just modify its marijuana laws in effective January 1, 2020, so that has changed a little bit. The second category here is that employers may be permitted to test for substances found in the federal government Schedule 1, 2, 3, and 4 of the Controlled Substances Act without restricting how the specimen is collected. So North Carolina is a state that follows those rules. Other states may require employers to follow DOT rules, that substantial set of regulations that I was talking about earlier for workplace drug and alcohol testing. You can find that if you're in Tennessee. 4, employers may strictly regulate what drugs can be tested for and what types of tests may be administered. And that's an example of some additional, state-specific requirements that aren't referring to different types of testing methods or regulations, and you can see that in Mississippi. So moving on to the OSHA issues now, and this is a very important piece that we get a lot of questions about, and that's related to post-accident drug testing. And the genesis of this rule really started back in May 2016 when OSHA's final rule on to improve tracking of workplace injuries and illnesses was promulgated. And it snuck in these provisions related to post-incident drug testing, not in the regulations itself, but in the preamble to the final rule. So basically the hundreds of pages that explain how the rule was adopted, its reasoning, and the agency's basis for issuing that rule. So there is some legal challenges associated with this rule that are ongoing, but as it stands, these post-incident drug testing limitations stand, and they've been in effect and have raised several questions for employers over the past over 4 years at this point. But what did the rule do? And this is what we're going to drill down and what's the key parts that you need to know as employers. So the rule said that drug testing may dissuade a reasonable employee from reporting a work-related injury because it's an invasion of privacy. Okay, going back to the privacy concern, and that's one of the main issues with drug testing. It's a privacy issue. So the only rule that came out of this, and the only limitation, was that employers are prohibited from conducting blanket post-injury drug testing. So in other words, you couldn't have a policy that said, and you still can't, anytime an employee suffers an injury or there's a workplace incident, that employee will automatically be subject to a drug test, right? OSHA viewed that and still views that as a form of discipline, and it deters the reporting of injuries and illnesses, and that was really the basis for implementing the rule in the first place. The entirety of OSHA's anti-retaliation provisions are designed to encourage employees to report injuries and illnesses. So OSHA's view is that mandatory post-incident drug testing is a form of discipline, and it deters employees from reporting those injuries and illnesses because they're afraid of a drug test, right? What did the test, or what did the rule say about other tests though, right? We've talked about a number of those, pre-employment random, and follow-up return to duty tests and the like. Well, it didn't touch any of those. It doesn't have anything to say about pre-employment tests, random drug tests. It permits all of those. And it also permits drug tests to comply with state or federal law. So for example, if you are an employee that is subject to the Department of Transportation regulations and that requires mandatory post-accident testing, then that is not a violation of OSHA's rule, right? So if there is another federal or state law that requires mandatory post-incident drug testing, you can implement that as part of your policy. So again, check to see whether your state permits mandatory post-accident testing, not permits, but requires it as part of your program and as part of the law. If it's required, if post-incident drug testing is required by a workers' compensation insurer, and that includes policies that provide for premium reductions for post-accident drug testing, that is permissible as well. You can implement a post-incident drug testing policy that requires drug testing following an incident if it is to comply with the workers' compensation policy. And then the key language of the anti-retaliation rule as it relates to post-accident drug testing is at the bottom of the screen here, and that's post-accident drug testing is permissible when it is likely that drugs or alcohol contributed to the injury and where the test can ID present impairment. So that was the original portion of the rule. That last part about where the test can ID present impairment, OSHA has softened its position on that because the only test that can identify present impairment is alcohol testing. You can't really do that for drug testing at the moment. So they retracted on that a bit, and now it is just that first half. If drugs or alcohol likely contributed to an injury or incident, you can conduct the post-incident drug test. Implementing that is really the challenging piece, right? So the rule prohibits drug testing employees for reporting work-related injuries without an objectively reasonable basis for doing so. So what OSHA says now is that it can be used as a tool to evaluate the root causes of a workplace injury. And that inquiry of whether an employer had a reasonable basis is identified by 4 factors here. And that's whether the employer had a reasonable basis to conclude drug use could have contributed to the injury. That's a bit circular. However, we have 3 other ones here. Whether other employees involved in the incident are also tested, whether there's a heightened interest in identifying drug use because of its high hazardous work that the employee is engaged in, and 4, whether the drug test is capable of measuring impairment at the time injury occurred. Again, that was only for alcohol tests, and these are the factors that were identified back in 2016. So OSHA did come out with some guidance on how this should be implemented, and there was some additional explanation in the rule. For example, it wouldn't be reasonable to test an employee following the report of a bee sting, for example. But there were other instances and examples in which it would be reasonable to test an employee or multiple employees to determine the root cause of that incident or the injury. So for example, if there's a crane operator and there was several employees involved in the incident involving the crane, the switcher, the operator, the loader, under those circumstances, if it's determined that drugs or alcohol may have contributed to the incident and it is objectively reasonable to believe that, it is fine to conduct that post-incident drug testing, but under those circumstances, it's not reasonable to just test the employee that was injured, right? If the injury or incident here could have been caused by any one of those employees, you need to be drug testing all 4 of them, or all 3 of them, any of the employees that were involved who caused or may have contributed to that incident. So in October 2018, after over 2 years of conversation about how this rule is supposed to be implemented and employer questions to the agency, there was confusion abound. OSHA did soften its position on those post-incident drug testing programs, as well as another element of the rule that it snuck into the preamble, those related to safety incentive programs. And what it had to say about the post-incident drug testing piece is that it can be used as a tool to evaluate the root cause of a workplace incident that harmed or could have harmed employees. And the genesis of this rule is very similar to what we saw in the original rule. However, it clarified that as long as you are not using a post-incident drug test to punish an employee as a form of discipline, so we reverted back to making sure that we're not using this as a form of discipline, you can conduct those post-incident drug testing on employees. Again, however, you don't want to have a written mandatory post-incident drug testing policy. This is more in the implementation piece and making sure that you're drug testing any employees that may have caused or contributed to that incident, not just the employee that was injured. So that's the key here. And other elements that you can do to beef up your program to make sure that you don't have a policy that appears facially to be what OSHA would deem retaliatory. It's important to make sure that you are encouraging employees to report those workplace injuries and illnesses as part of your overall program. The more that you can show that you're taking steps to encourage that reporting and you're not using drug testing as a form of discipline or something to catch employees doing something wrong all the time, the better.
Okay, thank you very much, Dan. And now I'm going to talk about spend a few minutes here on the Americans with Disabilities Act and how that relates. As Dan had mentioned, discrimination is one of the various things you need to be aware of when you're considering whether or not to drug test and or how you're drug testing. And specifically, disability discrimination ends up being the most significant legal risk in engaging in drug testing. The background is that drug testing, some people are a little confused by this, but drug testing is allowed under the ADA because the ADA does not consider drug use a disability, but you have to be careful with that. The ADA protects disabled individuals from discrimination if they're qualified to do the job, and in some cases, drug addiction can be considered a disability. In particular, individuals who have recovered from drug or alcohol addiction may be protected under the ADA if they're qualified and they now no longer are abusing drugs or alcohol. However, this protection does not extend to those who are currently using or abusing drugs in any way, and especially in a way that's against company policy. But just before I get any further, I just want to reiterate, Dan was talking about the various OSHA implications, and OSHA and the ADA and employment law, they're all intertwined here because the primary reason many organizations require drug testing is to keep the workplace safe. And, it can be argued that employers who are ensuring that their workplace remains drug-free are doing so in order to create a safe environment for employees. And that is fine. Under OSHA, you have an obligation to create a safe environment. But by engaging in drug testing, this in essence creates some sort of legal liability for employers who haven't taken all the necessary steps to ensure that any policy and procedure that they have are complying with all legal requirements. And that is really, the purpose of what Dan and I are doing here is to make sure that if you decide to engage in these types of drug testing, actions, which you are permitted to do certainly, and in general, and even with marijuana in most cases, we want to make sure we're at least giving you the framework to protect yourself from legal liability. So in terms of going on to the next slide, as Dan had mentioned earlier, drug testing could be discriminatory, could be viewed by a court to be discriminatory if the policy is not implemented consistently. And let's take a step back from the ADA for a second and just say generally, if applicants of a certain race or national origin or disability are tested as a condition of employment, but others applying for the same position are not tested, then that would be a discriminatory application of an otherwise legal drug testing policy. So basically, keep in mind that it's legal to test across the board as a condition of employment in a certain position, but it's typically not legal to only test certain individuals for the same position. That doesn't mean you need to test your entire company, either one way or the other. It is lawful to require drug testing for only some positions and not for others, such as those with a safety concern. But there really shouldn't be any scenario in which you're only testing some individuals in those safety-sensitive positions and not others. And then in terms of disability discrimination, since some disabilities require medication, it's possible that medication may show up in drug test results. And then if the positive result on the test from a prescription medication, assuming that medication is being taken in a way that's consistent with how it's legally prescribed, then it may be discriminatory to hold that positive test result against the applicant. In other words, let's say you either fire an employee or deny their application is denied because of a positive drug test, and it ends up that his or her medication was legally prescribed for a disability. As the employer, you could be liable for the adverse action that was taken by firing or not hiring this individual. So that's just something you really need to keep in mind when administering the tests. And in terms of the ADA, hopefully many of you on this call are familiar with what's called a reasonable accommodation. And what everyone doesn't always realize is that the reasonable accommodation obligation doesn't only start once you hire the employee. It actually starts immediately when the employee applies and you're in the process of deciding whether or not to hire this employee. So let's say an employer, a prospective employee has some sort of disability that might require a different type of drug test or might require some other accommodation or some other way that you need to treat this individual that is different from how you treat individuals without disabilities in terms of how you interview or how you onboard this employee in conjunction with the drug test, you are required as the employer to at least engage in the interactive process with this, let's say, applicant, and potentially make a reasonable accommodation to allow this individual to apply for and be considered for the job, so long as the accommodation does not cause an undue hardship for you as the employer. So let's say for whatever reason, let's say you require a urine sample, and for whatever reason this individual's disability does not permit him or her to provide a urine sample, but he or she can provide a hair sample. That likely would not be an undue hardship for you to take a hair sample instead of a urine sample. And there are other examples of things of that nature, but that's the type of thing we're talking about. If it's a different drug test that would cost thousands upon thousands of dollars for your company to administer, then that certainly may be an undue hardship. But I've seen too many cases of an employer just saying, we don't want to make an exception for you, even though it wouldn't have caused an undue hardship at all, and then the employee can assert, a claim for disability discrimination. So that's something we really want to be cognizant of. And that brings me to one case I want to discuss with you, and I've tried to limit these slides so I don't go in depth and talk too much about case law and bore you all too much. But this is an important one coming out of Massachusetts for a couple years ago that shows the intersection between medical marijuana and disability discrimination. And in this case, the plaintiff used medical marijuana at home to treat her Crohn's disease, and thereafter she was required to take a drug test and fired. And the company said, sorry, we follow federal law, not state law, so even though medical marijuana is lawful in Massachusetts, you are thereby terminated. And the plaintiff, claimed disability discrimination in violation of the state marijuana law. And, after going back and forth in the courts for a little while, the Massachusetts Supreme Court eventually ruled in favor of the plaintiff and held that she was disabled, and therefore the court rejected the company's claim that her use of a quote-unquote illegal drug under federal law rendered an accommodation that was unreasonable under state law. In so doing, the court relied on language in the state medical marijuana law which prohibited the denial of any right or privilege on the basis of medical marijuana use. And the court found that where a disabled employee needs medication to alleviate or manage a medical condition, that is the reason that renders her disabled, and the employer fires her because the company policy prohibits the use of that medication, the law can't ignore the fact that it is the company's policy that resulted in a person being denied employment specifically because of her disability. And the court further held that by proving that there was no duty to accommodate the on-site use of medical marijuana, the legislature specifically intended to accommodate off-site use. And remember, in this case, the plaintiff was using marijuana at home, off-site. This is not the case where the court didn't say that the employer had to permit her to use medical marijuana at her place of employment. It was just that it did not have to permit the use of marijuana at her home. That was the whole dispute. So moving specifically now, that was kind of the segue I wanted to use just to talk about marijuana specifically now in the last 10 minutes or so of this presentation. And just to set the stage, we just have a few statistics we wanted to show here that, at this point, this is, as of, 2.5 years ago, 45% of Americans had tried marijuana and 12% actively use it. And at this point, with more and more states legalizing it, I bet you it would be over 50%. And this continues every year. It continues to be the highest percentage of people who have tried marijuana since the late 60s. And there's actually an increasing number in both parties. It's not surprising with Democrats, but also with Republicans in favor of legalization of marijuana. And a recent Gallup poll showed that over 65% of Americans believe smoking marijuana is morally acceptable. So with that kind of background of those statistics, we're up to how many states now have legalized marijuana. And over the years, Dan and I have given similar presentations. And at some point, this number was in, I believe, the low 20s just a few years ago. And now it's up to 33. And I'm not going to read all the states, but you can see the list of all the states. It seems like every year, 2 or 3 more become lawful. Some years it's a little more, some years it's a little less. But since I think it was 2008 when California and some of the West Coast states legalized marijuana for the first time, it's just been a consistent increase in these numbers. And you can see from the next slide that we specifically now have parsed out the 12 jurisdictions, including where Dan and I are in DC, that have legalized recreational marijuana. And, you know, when you're deciding about your drug testing policies, you know, it is a difference between the 22 or so states that only permit medical marijuana and the 12 that permit both medical and recreational. And that is just something, you know, you need to be aware. What is the law in your state? Do you fall into this list? And as a result, what policies are you going to implement to comply with the law? So the first step is knowledge, and then the second step is application of that knowledge. And moving on to the next stage about medical marijuana, although a lot of this, you know, you should be thinking of recreational marijuana too. You know, the crux of this is, as Dan mentioned, and I'll mention probably a couple more times, is this, you know, the dichotomy of marijuana remaining illegal under federal law, but being lawful in some states and not others, and then recreational being lawful in other states. You know, that patchwork of laws creates so many uncertainties for employers when trying to implement and apply workplace policies across state lines. It's not even easy if you're only in one state, but employers who are in multiple states with all of these different, you know, some being unlawful, some being partly lawful, and some being all lawful, really creates uncertainties, especially when you deal with the ADA and like that Barbudo case I mentioned from Massachusetts that implied state law obligations, in a sense, overrode the ADA's obligations. And as Dan had also mentioned earlier, you also need to make sure you comply with drug testing procedures in each state when dealing with medical marijuana issues. And, you know, one more list I have for you here on this next slide is about which states have specific anti-discrimination provisions in their medical marijuana laws. Of course, you know, Massachusetts does, because based on that case I explained to you a few minutes ago. And, you know, hopefully the counsel who was representing the company in that case knew about that law, because that's exactly the law that the plaintiff sued under and eventually prevailed. So if you are located in any of these states, you really need to be careful based on these specific anti-discrimination statutes, where you want to consult with your legal counsel and really be careful before you potentially take an adverse employment action or decide not to hire an individual because of a positive drug test. So back to the kind of overarching question where we had teased this in the beginning of the slide is, you know, whether you may lawfully impose discipline, you know, such as including termination for an employee who tests positive for marijuana. And based on what I just said in the last slide with the different states with those anti-discrimination statutes, I think it's pretty clear at this point that the answer really does vary depending on the state in which you are located. And again, if you're located in more than one state, it will likely depend on where is the employee located and where is the disciplinary action going to occur. But, you know, if I have to just give you one answer, you can see on the next slide, generally the answer still is yes. The employee, there's no Supreme Court case or there's no law at this point that from a general federal perspective says that calls into question that you do have the right to discipline an employee for a positive drug test, including a positive marijuana test. For the most part, the answer is yes, you can do that. And specifically, most states do allow employers to prohibit the use of marijuana on the employer's premises as well as on the job intoxication. That is pretty much a guaranteed no-no unless there's a specific medical related reason. But for the most part, you certainly can have policies where you prohibit on-the-job intoxication and or use. And there is some case law supporting an employer's right to terminate when an employee tests positive. And I'll get to one other case in a minute that I will want to talk to you about. But just to reiterate here, I purposely set this up in this next slide, is a key question: can an employer discipline an employee for off hours and off-site use or influence? And you just need to keep in mind, is it pursuant to a valid prescription for medical marijuana states, or is it for off hours and off-site recreational use in recreational states? And then keep in mind whether those states that were on that list a few slides ago, such as Massachusetts, Minnesota, Rhode Island, whether there's a statute in your state that expressly prohibits employers from firing an employee for a positive marijuana test or having a valid marijuana card. Interestingly enough, some of those states that people assume are kind of at the forefront of marijuana, that were some of the initial ones to legalize marijuana, such as Colorado and California, actually don't have those anti-discrimination statutes, and employers may lawfully implement zero-tolerance drug use policies in some of those states. And I'll talk about, I'm going to end the presentation in a few minutes talking about the positives or negatives in doing so. But before I do that, I just want to get to this issue of lawful off-duty activities. And a handful of states have lawful off-duty statutes that are typically aimed at protecting an employee's rights to free speech, so they cannot be fired for engaging in political activities that their employers may disagree with. But these statutes, also apply to personal and lifestyle decisions. So you need to be careful. If you take an action against an employee with a positive drug test, it's possible that action could run into issues with these lawful off-duty activity statutes. So this is something else that you need to be aware whether your state actually has such a statute, because an employee who tests positive for marijuana could potentially claim that he is protected from termination so long as his use of the drug occurred during non-working hours. And the most well-known case occurred in Colorado under a lawful off-duty activity statute called Coates versus Dish Network. And I'm not going to get too far into the weeds on this case, but in this case, the employer actually won. The court found that its termination decision was lawful when it terminated the employment of an individual because he took medical marijuana. And the employer said it was lawfully entitled to enforce its zero-tolerance policy. The employee argued based on the fact that he was engaging in lawful off-duty conduct. And again, the Supreme Court of Colorado held for the employer and said, you know what, in this case, the zero-tolerance policy applies, and the employer was permitted to enforce it regardless of that lawful off-duty activity. While it was lawful for the plaintiff to take medical marijuana and not criminal, there was nothing in that statute that protected him from any adverse employment consequences. So that is a case, as I say in this next slide, that is a significant case for employers, and it strengthens the right of all employers in all states to continue to enforce zero-tolerance policies, but that being said, I want to put a big caveat there. There's always test cases that are occurring, and that was 4 years ago, and the climate has changed even since then. So employers still should reassess blanket bans on marijuana use, and think about whether or not policies should be revised. Don't just this is only a case in Colorado. And even in Colorado, it doesn't mean that at some point the Colorado Supreme Court can't change its mind. So with that being said, I'm just the last few slides here are going to be more about practical aspects for you to consider instead of me just talking about a case law or talking about the actual law. Well, let's talk about practicality. When you're deciding what to do, you need to think about, will a zero-tolerance policy on marijuana reduce your pool of qualified candidates, potentially to an unacceptable level? That is certainly something that you really need to consider. Will failing to test for marijuana increase workplace injuries or absenteeism? And will treating marijuana differently than other illegal drugs create problems in my workforce? And depending on the answer to those questions, you could be further towards your conclusion of whether or not you want to continue to test for marijuana. In terms of zero tolerance policies, we're finding that more of our clients want more flexibility and less bright line policies, but that's certainly not unanimous across the board. As the slide says, some employers are softening zero tolerance policies, particularly for jobs where safety is not an essential function. State laws allowing marijuana use are complicating recruiters' efforts to find drug-free employees, which is what I was referring to on that previous slide. So before relaxing zero tolerance policies, you might want to, make sure to get buy-in from company leadership that supports the move and how to deal with any consequences as a result. You really want to consider your risk tolerance for the workforce and risk tolerance for litigation, potentially, resulting from some sort of allegation of a discriminatory policy. No changes in your policy or practices should excuse an employee who is impaired while working. So even if you get rid of, drug testing for marijuana in certain situations, you want to make sure not to excuse any employee who is impaired for working. I haven't seen any indications that employers are relaxing standards for jobs that are safety critical, but drug policies for positions that entail relatively low risk of injury or error, such as clerical or knowledge economy-based jobs, those are the ones that we're seeing the most of. And just to finish up here, because I want to keep this exactly at 1 hour, is several notable updates from the last 6 months is that Illinois has legalized recreational marijuana use, but specifically has provided workplace protection for employers. It's a really good law for employers that most other states do not have, to basically say, give a carve out that drug testing, the burden of proof is assuming that drug testing is reasonable and non-discriminatory, at least for random drug testing. So anyone in Illinois should really be aware of this new law. Both New Mexico and Oklahoma have passed legislation that prohibits employers from discriminating against employees because of their status as a registered medical marijuana user. So you should really, put them in that list that I described earlier. Also, Nevada specifically has been creating new laws, and this is one specifically as of a few months ago, that prevents employers from failing or refusing to hire an applicant because an applicant tests positive for marijuana. So again, this is just another reason you need to be aware of these ever-changing laws. Before January in Nevada, you could do that, and now you can't. In New York City, passed a law barring most employers from conducting any pre-employment testing for marijuana or THC. And likewise, New Jersey now prohibits employers from disciplining or terminating employees solely based on that individual's status as a registered medical marijuana user. So all of those are slightly nuanced and slightly different from each other, but they all contain, you know, some similar aspects. And really, just as an employer, there are things, again, you need to be aware of and knowledgeable about, and then we have to figure out how to apply that knowledge to your drug testing policy. And yeah, we don't like keeping you more than an hour, so this is our contact information here. Feel free to send us an email, give us a call. Dan and I would be happy to answer any questions you have relating to drug testing or marijuana, and help walk you through any tricky issues that you might be experiencing. And continue to look at our blogs. This presentation had both employment law and OSHA-related aspects. So check out our OSHA defense report and our employer defense report, where Dan and I and other members of our firm write about these issues all the time. We try to at least publish an article at least once a week, sometimes more. And our website has a lot of information, included COVID-related information, if you need any more assistance on that front. And we will continue to be giving these webinars every month, both OSHA-related and employment-related webinars. So on that note, thank you very much for joining us. We hope it was useful, and we look forward to seeing you next month at our next webinar. Thank you.